Okay, so you've made the decision to go out in the marketplace to do your due diligence and to find a trusted resource to do your estate planning documents. Good for you. This is a great and important first step. Now, as a courtesy, this is a shopping list of items that you'll want to make sure are included in your trust to ensure that you achieve the best possible outcomes. Now, the first item that you want to look at is Hipaa compliance. As we all know, Hipaa is involved with virtually everything having to do with medical privacy and ownership of property. So your documents, your trust, your powers of attorney all need to be Hipaa compliant. A properly drafted trust will also have stretch IRA provisions included in it, which allows for the continued tax-deferred stretch of individual retirement accounts and 401k accounts. A properly drafted trust will also include language that provides for the protection of these assets to your children and grandchildren. Most trusts do not, so it's important to have trust protector language included in your documents. New techniques have allowed us to provide surviving spouses with varying levels of control over making changes to a trust once the first spouse has passed away. Traditionally, surviving spouses have no power to make changes to the B trust or the decedent's trust upon the first death, but we draft documents that allow more flexibility. Medium level of control gives the surviving spouse the ability to remove a beneficiary if they're not being nice to them, but prevents them from adding a new beneficiary like their new spouse. Maximum control over making changes to the B trust allows a surviving spouse to make any change he or she needs or wishes to make after the first death. This provides maximum flexibility, but it's not appropriate for every circumstance. So it would be important to discuss your circumstances and give you enough information to determine which is the best approach for the level of control that you give the survivor of your trust. No contest provisions are very important. Provisions that state that if someone contests the terms of the trust, essentially they disinherit themselves. That's designed to keep peace in the valley. You want to be able to make specific gifts in your trust as well. If you can't state that you want this watch to go to this individual, this dollar amount to go to that individual, that's an important piece that many people like to have the ability to make gifts in their trust. We also allow our clients to create specific ultimate beneficiaries. In other words, if the clients, their children, their grandchildren, all of their lineal blood descendants perish, the automatic default is not simply heirs at law, but we give clients the ability to select individuals, family members, friends, charities, foundations as the ultimate beneficiaries of their trust estate. Another very important provision in a trust is movability. You want your trust to be portable. If you choose to move from one state to another, you don't want to have to redo the whole trust. So movability or portability provisions in a trust are very important as well. They allow you the flexibility to move without having to change the entire trust. One can also use a trust to provide a life estate and real estate for a loved one. Let's say mom passes away but has a child that would benefit from being able to stay in that house for a period of years, or a spouse, a second or third spouse, whom they wish to give rights to live in their house after they're gone for a period of years or for their lifetime. Spendthrift provisions are provisions that protect a beneficiary's inheritance from being taken by creditors, judgments, lawsuits, and other lifestyle issues. Successor trustees' duties. It's important that your successor trustees have accountability to your beneficiaries. So it's important that your trust provide adequate protection for your beneficiaries to make sure that the trustees are doing their duty and meeting their obligations to the beneficiaries. Qualified subchapter S corporations. Certain language is required in a trust to allow a successor trustee to continue to operate a subchapter S corporation. So it's important, if you operate a corporation, it's important to have that kind of documentation and that kind of language in your trust as well. Conflict resolution language. This is language that states specifically that lawsuits are not permitted, but rather arbitration is the suggested course of action if there's a dispute. That tends to save time and money in the event of a dispute. In our trust, we're proud of the fact that successor trustees have certain limited powers to make changes to the trust, because over the years I've seen many times a successor trustee painted into a corner because the trust does not provide flexibility for changes. So a well-drafted trust will provide the trustee, the successor trustee, with the ability to make changes to save taxes, to correct an error, or to improve the trust in the best interest of the beneficiaries if everyone can agree to it. It's important also to have instructions within your legal documents that give the trustee some ability to push back against hospitals or medical care providers who are not willing to disclose medical information for purposes of declaring a client incapacitated. That declaration of incapacity allows a successor trustee to spring into power under certain circumstances, so it's important to have some teeth in the provisions that allow the medical care provider to disclose personal medical information to a successor trustee. And then finally, it's very important that you ensure that the person who is in front of you talking with you about an estate plan is not selling you a financial product of any kind. So these are some of the things that are on our shopping list when we look into the marketplace for the best solutions, and we hope that these will be helpful to you as well. Feel free to give us a call anytime at 877-438-7878. We'll be delighted to help you. Thank you.